One situation I see all the time in my practice is clients who are facing the following extraordinarily frustrating situation. They have been financially responsible, they have been careful with their credit, and through no fault of their own, there are significant errors on their credit report. And to make it worse, when they contact the credit reporting agencies about those errors, whether we're talking about accounts that aren't theirs and are on the report because of identity theft, whether we're talking about servicing errors, payments that were made on time that are listed as late, etc. When they contact the credit reporting agencies about these errors, the credit reporting agencies refuse to fix the problem. Now, that dispute with the credit reporting agencies that I just mentioned, where you ask them to fix it, is normally the first step. The question is, what do you do if that doesn't do the trick? What do you do if they don't fix it? My name is Dan Schlanger. I'm the managing partner at Schlanger Law Group, and we work on inaccurate credit reporting litigation as a core part of our practice. Luckily, the Fair Credit Reporting Act provides really powerful remedies for consumers who are in this situation. So typically these lawsuits are about the failure of the credit reporting agency or the credit bureau, Experian, TransUnion, Equifax, etc., to conduct a reasonable investigation when they're presented with the dispute. And in addition, typically these litigations include claims against the furnisher of the information that's incorrect, which will typically be a credit card company or other lender, although it can be other sorts of entities such as debt collectors. Now, if you prevail in an action like this, you're entitled to some really powerful remedies. Not only are you entitled to your actual damages, which can include the damage to your credit that was caused by the failure to respond appropriately to your dispute, but you can also recover potentially other sorts of actual damages, such as emotional distress damages. You can recover statutory damages if you can show that the misconduct was willful, and that, is not always so easy. But if you can do that, you're even entitled to punitive damages, and you're entitled to your attorney's fees and costs. Now, that last piece, that the prevailing consumer is entitled to attorney's fees and costs, is why private law firms like Schlanger Law Group can work on litigations like this. We can work on these cases on a contingent basis, where we recover only if we win or settle, and we don't need to bill the client monthly out of pocket for our time. These litigations can often be pretty extensive. The typical defendants, the credit reporting agencies, and the furnishers are, obviously represented by sophisticated counsel. They raise a variety of defenses. Now, if you practice in this space, you're accustomed to these defenses, and you know how to respond. This is not an area of law that a typical general practitioner will be familiar with. Many general practitioners, some of whom are phenomenal lawyers, go their whole careers without ever litigating a Fair Credit Reporting Act case or even hearing about or knowing about the Fair Credit Reporting Act. If you're in the situation I've described, meaning you're a consumer, you've disputed with the credit reporting agencies, they failed to fix it, and you have suffered harm as a result, the next step, and in some cases really the only practical step you can take to get back on your financial feet in terms of repairing your credit, which you've worked hard to maintain, is to bring a lawsuit against all of these defendants under the Fair Credit Reporting Act. If you're in this situation, Schlanger Law Group would be happy to speak with you about your case to see if we can help. Have a great day.